The next case is COURSEY versus R.J. Reynolds. How much time would you like for rebuttal?
I'd like 5 minutes, if that's okay.
Okay, whenever you're ready.
Good morning, Your Honors, and may it please the Court. My name is Andrew Greenlee, and I'm here on behalf of Ms. COURSEY. Your Honors, there was no evidence presented of any cancer that was ever found in either the colon or the breast, and yet the defendants argued at some length during the course of trial that it could have come from her colon or it could have come from her breast.
Is there evidence that was introduced that she'd had a lumpectomy in her breast?
There was, but the important part about that evidence is that it came back negative. So the only evidence of breast cancer, or related to breast cancer, was the absence of evidence of breast cancer. And Judge Rouse, nevertheless...
And that evidence, as far as the negative test results, that was a medical document, or was that what was in the notebook?
That was in the notebook. That was in the notebook, which...
That was her personal notebook.
It was her own personal, kind of like a diary. So there was actually, in fact, no medical records whatsoever that had any indication that there was either cancer in the colon or cancer in the breast. All the medical records uniformly said lung cancer. Probable.
Well, you say all the medical records. The medical record you're relying upon, really the only medical record that you're relying upon, is the certificate of death. Is that correct?
That's not correct. There were, I think, maybe 4 to 5 different medical records. In each individual one, it had a mention of lung cancer. So, look, there was not a wealth of medical evidence in the case, but the only...
You're talking about going back how far? How many
She died
years?
in 1992.
Yeah, but before that, we're talking about, you know, a huge gap where there was no medical records at all, correct?
Yeah. There were very few medical records that were found, and that's just the nature of the case. Now, was there evidence that she died of adenocarcinoma of the lung? Absolutely, absolutely. I mean, in the death certificate.
Just to make sure, you're saying that the only reliance that the tobacco company could place on any other cause of the cancer was the colon or the breast. She had a lumpectomy. We all know that a lumpectomy could be cancerous and it could not be, but there's nothing in this record, nothing that they presented to indicate that the lumpectomy was positive for cancer.
Quite the opposite. The lumpectomy came back negative.
Negative for cancer.
Negative for cancer. So again, I mean, and I can't emphasize this enough, the only evidence of breast cancer was a negative lumpectomy result.
Her testimony regarding a family history, did I read something about her sister having breast cancer?
Her sister died of breast cancer. Look, our position on that, and I'd like to transition to the Mack case here. First off, with regard to Mack, it's not this case because it was undisputed where the cancer came from. It was laryngeal cancer, and there was no dispute on the side of the defense on that particular point. The question was, in Mack, what caused the laryngeal cancer? And he had significant exposure to asbestos.
Do you know of any case where the court ruled it sufficient that because a decedent's brother or sister may have had cancer, that therefore entitles them to argue that that's a sufficient evidence of causation, that perhaps the cancer in this particular case was caused by breast cancer or colon cancer because the sibling had it? Are you aware of any cases?
I'm aware of no case.
Either.
I don't think there is a case. I've looked. At least not from Florida. I can say that was an issue in Mack. There was evidence that there was a family history, but it was family history plus significant exposure to asbestos in the workplace and other toxic chemicals. So I think it was, Mack to me is an obvious case. They can say, well, yes, especially with respect to asbestos. The laryngeal cancer came from the asbestos. It didn't come from the smoking. That's a fair inference. And then it's a jury question, right? That's not this case. Here, Judge Rouse seemed to think, and I'll quote here, "A defendant can apparently argue that cancer could have spread there without a showing of cancer elsewhere in the body, that there are these 58 places that cancer can start and spread to the lung." Now, I have a tremendous amount of respect for Judge Rouse. He's a very fine judge, and I think he would have made a great appellate judge. But I think he got that particular ruling wrong. I don't think that you can say that somebody had turf toe and a surgery in the 70s and say, well, oh, Bob Marley, he died of cancer from his toe, therefore maybe it came from his toe. I just think there has to be, and this is what the cases say. I mean, if you look at the Arizona chemicals case, there has to be a competent evidentiary link. In other words, there has to be some foundation in the evidence that connects the theory of defense with the facts of the case. And there simply wasn't that here. In fact, all the evidence specifically excluded these alternative theories of causation.
So what did you have to prove as far as, this is what they would refer to as the phase 2 part of Engel in your case, is that correct?
We had to prove that this was phase 1. It was the threshold showing that we had to prove, number 1, that there was addiction, and number 2, that her addiction to nicotine was the legal cause of her death. I'd like to speak a little bit about the proposed application of the two-issue rule that my friend on the other side is advancing. We think that it's completely foreclosed by the Grenitz case. In Grenitz, the two defenses, they called them, were the absence of negligence and the absence of causation. And the Supreme Court rejected that. And that's essentially what the two elements that they, well, it's not the same two elements, but they defended on the basis of two different elements: the absence of addiction and the absence of causation. And so we think that it falls squarely within Grenitz. The fact that there are different causes of action have no bearing on this, because there were just two elements for the initial phase 1 threshold Engel class membership. And again, those are legal causation and addiction. And so the two-issue rule is completely inapplicable.
What were the defenses in this case? I mean, were there two or more defenses, or was there one defense?
Well, there weren't affirmative defenses. They were just saying that we didn't meet our elements. It was essentially, we couldn't prove that that she was addicted to cigarettes, and that we didn't prove that her addiction to cigarettes were the legal cause of her death.
Well, and what was your proof of addiction?
We had that she smoked for 31 years, multiple packs a day, that she would, if she would wake up at night and had to go to the bathroom, she would smoke several cigarettes before she could go back to sleep. She attempted to quit, and when she tried to quit, she would cry uncontrollably. It was incredibly painful for her. The only way that she was actually...
Was there any evidence that she actually did quit?
Yeah, there was. And you know how she quit? She got Guillain-Barré, a rare condition that was paralyzing. So she physically couldn't lift her fingers to her face for a significant amount of time to even smoke a cigarette. And it was only at that point, after more than 30 years, that she was able to quit. And that, with the significant help from her family members, who threw out all the ashtrays, threw out all the cigarettes, repainted her apartment, threw out her drapes. So she had it was a family effort to get her to quit cigarettes. And then, and only then, was she able to quit smoking.
What other evidence of addiction did you have, other than it was the family members' testimony as far as usage, correct?
It was the family members as far as usage, plus Dr. David Burns, who used to work for the Surgeon General. He gave an expert opinion that she was addicted to cigarettes and that her addiction to cigarettes was the legal cause for her death. We also attempted to try to introduce the testimony of her family members who witnessed her addiction. I mean, in the same way that I could say this isn't true, but I could say my uncle.
You introduced their observations. That came into evidence.
Right.
You tried to introduce their opinion testimony about whether or not she was addicted. That would be the family members, correct?
That's right. That's right. And in the same way, look, if they're allowed to introduce evidence on these speculative theories of causation, it becomes a fairness issue that we're not allowed to introduce this evidence on addiction. In the same way that
Only because that's a jury question, and they can't testify to what is ultimately the province of the jury.
Well, I think
the
they can-
ultimate issue.
I think
of whether or not
they
she
can
was addicted.
testify. They most certainly can testify as to the ultimate issue. I think that if it's rationally,
They can give opinion testimony?
I think so. Yeah.
You think so? Is there any either case law or?
Yes. Ballard.
There is.
Ballard, Grossman.
Hold on. Lay opinion witnesses can give what amounts to expert medical opinion testimony.
Well, I would resist the premise that this is expert medical testimony. But yes, there are cases affirming the introduction of lay testimony as to addiction. There's Ballard, there's Grossman. The cases are cited in our papers. Now, the defense brings up a fair point that I haven't encountered any cases that say it's an abuse of discretion to preclude lay addiction testimony. But there's a first time for everything. And we think on the facts of this case, given that we had this burden of proving addiction, that they should have been in the same way that I could rationally say based on my own experience, my uncle was a drunk. It's not true, but theoretically somebody could testify to that.
What was the doctor's opinion regarding addiction?
Which doctor?
Was there any medical testimony from a doctor concerning addiction, and what
Yes,
did
yes.
the doctor say?
Dr. Burns testified that she was addicted to cigarettes and that her addiction was the legal cause of her death. And Dr. Schopel was prepared to give an addiction opinion. This Dr. Schopel, Stanford educated, Northwestern educated, highly qualified.
Is Dr. Burns' testimony based upon his personally, and did he examine the plaintiff, or is it his review of the medical records?
It's his review of the medical records and the smoking history of the decedent and his extensive knowledge of the addictive properties of cigarettes and the nicotine of cigarettes, which, by the way, cigarettes are addictive. That's res judicata in these Engel cases. Surely, if someone were to do heroin every single day for 31 years, I don't think there'd be any question that they were addicted to heroin. That's a more than fair inference for someone to draw. So I think that it's more than fair.
So there was evidence that she tried to quit in the past.
Yes.
But the record indicates how many times did she try and quit?
There was at least one quit attempt, at least one.
Was she able to quit for any period of time? Lay off the cigarettes for any period of time?
She attempted to. She attempted to.
I can't hear you, sir.
I apologize. Let me fix that. She attempted to quit. She cried uncontrollably. Ms. COURSEY testified. Excuse me.
Period of time was she able to stay away from the cigarettes?
I don't recall the exact duration of the quit attempt.
There was that period of time when she had that disorder
That's right.
that she was unable to.
She was physically prevented from smoking. She couldn't physically. She was paralyzed.
Was there any indication in the record of how long that was? Because I do know that she did manage to quit after that
That's
episode.
right. That was a matter of, I think it was a matter of months. I think somewhere in the neighborhood of 6 months or so that she was paralyzed. And
Are you aware of any case law that says that it's an absolute necessity that you have to have medical testimony from a medical expert regarding addiction?
I'm not aware of any
not
case law
either.
that says that. That doesn't mean, though, it doesn't mean that we should be precluded from introducing medical
No, obviously
testimony.
the doctor can give an opinion as to whether, the person is addicted or not, but I'm trying to understand why, a relative or someone that knows the person real well and knows the habits of the person can't give an opinion as to whether they thought the person was addicted based on years of knowing the person and observing the person's habits.
Right. And that's...
Anyway.
Do you know if the jury made a determination based upon what they heard at the trial that they found the decedent to be addicted or have been addicted to cigarettes? Do we know that from their verdict?
We don't know it. There was no special interrogatory on addiction. There was just one general interrogatory that collapsed all the elements of the Engel class membership question.
The whole case, it was one question to the jury, correct?
That's right. That's right. There was one question to the jury on the verdict form, and well, there were multiple questions, but the jury had to stop at that threshold question as to whether or not there was sufficient evidence to establish that she was a member of the Engel class. It's our position, Your Honors, that there was overwhelming evidence, in fact, that she was a member of the Engel class. And we think that the judicial process somehow got
You
short-circuited.
say there's overwhelming evidence of the Engel class, but yet you're criticizing the judge for not allowing the testimony of Dr. Schopel to come into the case. That seems to be, to me, contradictory. Are you saying, but for the testimony from Dr. Schopel, you would have gotten a verdict? That kind of flies in the face of we had overwhelming evidence.
There was our argument here today is that it's the cumulative effect, right? It was the introduction of this alternative, speculative, unfounded alternative causation evidence. It was the preclusion of us being allowed to bring Dr. Schopel to give a medical testimony on addiction. And then it's a topic that we haven't gotten to, but the closing arguments, we think those were incredibly prejudicial. And we know what the burden is under Murphy. We embrace the burden. We do think that if ever there were a case that called for reversal under Murphy, particularly if you view the evidence and all the arguments on appeal cumulatively, we think this is the case. And if there are no further questions, I'd like to reserve.
Every time, okay.
Your Honor, the prior attorney.
Thank you very much.
All right, you may proceed.
May it please the Court, Jason Burnett for the appellee, R.J. Reynolds. Good morning, Your Honors. I'd like to start with the addiction opinion.
Yeah, why do you need an expert to tell a jury that a person for 30-some years that smokes 3 packs of cigarettes a day, that wakes up at night and has to have cigarettes, and people that know this person, observe this person, and know the person well can't give the same opinion?
So the only addiction testimony...
What case do you have that says that lay people that know the decedent or know the individual are not able to give an opinion like that? Is there a case law that says you have to have medical testimony?
Not to my knowledge. We cited some cases outside of Florida dealing with alcoholism and insurance context or employment
Does it make sense
context.
to you that in an issue like addiction, physical addiction to cigarettes, that you need medical, a doctor who may have examined the person just a few times to render an opinion, as opposed to someone that's known the decedent all their lives or for a substantial number of years, that person would be in any different position than the doctor to say that the person's addicted?
You do, because of the way the addiction issue was presented in this case and in all other Engel progeny cases. Right. There was one witness for the plaintiff, Dr. Burns, who testified about addiction, both generally and that this person, Ms. Friedenhagen, was addicted to cigarettes. He used a definition of addiction, from the National Institutes of Drug Abuse, and that definition is addiction is a chronic, relapsing brain disease characterized by compulsive use despite harmful consequences. And he testified at length over the course of a day.
So if we render an opinion that says that medical testimony is required to establish that element, we would be the first court to say that, right?
To my knowledge,
I think we would be.
you would be the first court to
Yeah.
actually apply the statute, 90.701.
Yeah.
The plaintiff has cited 3 cases in their briefs, Brown, Ballard, and Grossman, for the proposition that it's not error to exclude lay opinion of addiction. In Brown and Ballard, those cases were about sufficiency of the
Well,
evidence.
it's not error to allow lay people to testify. Lay people can render an opinion as to whether their brother or sister or mother or father or close friend or even a distant relative is addicted based on their history of knowing the person, observing the person, and that sort of thing. A lay person is entitled to render an opinion that that person is addicted to cigarettes based on that knowledge, right?
I disagree, Your Honor. This is issues governed by a specific statute, 90.701. There's not even a discussion or an attempt to meet that statute in the plaintiff's briefs. And in the cases that they've cited, Brown, Ballard, and Grossman, not even a citation or mention of that statute. And under that statute, 90.701, for lay opinion testimony to come in on addiction, and that's the ultimate issue in this case, opinion testimony has to meet two criterion. They have to be able, the lay witnesses are not able to testify without resorting to the inference or the opinion, and it doesn't involve specialized knowledge. Well, we know that the lay witnesses here could testify without resorting to opinion because they did. Mrs. COURSEY and Ms. Friedenhagen testified about the smoking behaviors of their mother, and they didn't have to resort to opinion testimony to do that. And it is an issue of specialized knowledge because we know from Dr. Burns' testimony here over the course of a full day about brain changes in the brain to the receptors in the brain and why that causes addiction. So it's a specialized medical issue. It would be completely misleading and confusing to the jury to have an expert come in and testify about the medical issues that arise because of addiction, and then have lay witnesses who have no experience or familiarity with that to try to match up their observations to the criteria for addiction provided by that expert. And to take a step back, the trial court did not exclude this evidence before trial. It made a ruling in limine and asked the plaintiffs to proffer that evidence. There was never any proffer of the evidence.
When you say that evidence, Dr. Schopel's and the lay witness opinion testimony, correct? That
Yes.
was not proffered.
Yes, Judge Wallace.
Dr. Burns testified, and he did testify affirmatively that there was an addiction. She was addicted, correct?
That's correct, Judge Wallace.
So basically what it comes down to is the jury, for whatever reason, we don't know, because we don't know how they decided the issue of addiction, they never reached the issue, correct?
That's certainly possible. The overwhelming evidence in this case, well, there was ample evidence, I should say, from which the jury could conclude that Ms. Friedenhagen was not addicted. The description just made was that there was at least one quit attempt. The record is there was one quit attempt. One quit attempt over the course of a day, maybe two, when Ms. Friedenhagen was at a beach house with her family. And she stopped smoking, and she cried, and she became jittery, and then she started smoking again. That was the single quit attempt described in the record. And the brother, Mr. Friedenhagen, he didn't even recall that attempt. So it was a factual dispute whether there was even one. But there was one quit attempt. And then, of course, after that medical episode, she quit smoking entirely in 1985 onward. Dr. Burns' testimony was that addiction is a chronic relapsing brain disease. There was no chronic relapsing in this case. There was one quit attempt that was not followed through with. The jury had ample evidence to find that Ms. Friedenhagen simply wasn't addicted. She enjoyed smoking, she continued to smoke, and she wasn't addicted. And when she wanted to
Let me
quit, she did
shift
quit.
gears just a little bit concerning your alternative theories of causation. I think you attempted to argue that it could have emanated from the breast or from the colon. So why don't you just tell me what evidence you had? The First District has held that to establish the relevance of particular alternative causation evidence, the defendant must prove a competent evidentiary link. So tell me what your competent evidentiary link was, that this cancer came from the decedent's colon issues or breast issues.
Well, we know that she did have the mammogram where the two suspicious areas were found, and the lumpectomy, which did come back negative. That is true.
The lumpectomy came back negative for cancer.
In 1988, lumpectomy negative for
Okay.
cancer. At that time,
Is that part of your evidence that she had a negative lumpectomy?
well, that's the context for the fact that she was then put on an expedited mammogram schedule every 6 months. Dr. Scheppel, plaintiff's treating physician, testified that the fact she was put on an expedited mammogram
Okay,
schedule.
so she was taking, in addition to the negative lumpectomy, which showed there was no cancer, is part of your evidence that she was taking mammograms every 6 months.
That's correct. Plus, the
Okay,
admission...
now what mammograms indicated that she had breast cancer?
There were no mammograms
Okay,
in the
so we
record.
have that she was taking mammograms. We have the negative lumpectomy. What else?
And Dr. Scheppel's admission that being placed on a mammogram schedule for every 6 months is an indication that a person is at an elevated risk of breast cancer.
So we have an elevated risk of, and you think that that's a competent evidentiary link that would allow you to argue to the jury that the cancer came from a negative lumpectomy, which showed no cancer, that she was taking mammograms, but there's no mammograms that showed that there was ever any evidence, and that there may have been heightened risk And that's your evidence?
But there's also the family history. Her sister had breast cancer.
Family history.
Just take a step
Okay,
back.
so we have a brother or sister or mother or father that died from cancer. So that entitles you to argue to the jury that there's a competent evidence that the cancer in this case came from the breast?
That entitles us to argue to the jury that they should not believe plaintiff's witnesses. This was introduced to diminish
Now
the testimony
we're down
of the
to the
plaintiff's expert.
believability of witnesses, right?
We're impeaching the testimony of the plaintiff's experts in this case who testified that it was lung cancer by pointing
Now,
out...
it seems to me, what other evidence do you have? So we have the negative lumpectomy, we've got the fact that she was taking mammograms, we got the fact that there was a relative somewhere that had cancer. What else?
Her sister, a first-degree relative, had breast cancer. Dr. Sheppel also admitted that a person with that kind of relationship who has breast cancer also indicates an elevated risk of breast cancer.
There's the only record evidence in the case that the lumpectomy was negative was in her personal diary, correct?
That's correct, Judge Berger.
And there was no autopsy taken, so we don't know, other than the fact that the death certificate says she died of lung cancer, there's no way of knowing whether that was a lung cancer that had metastasized from some other area.
That's correct. You have to consider the context of this case. There were 4 pages of medical records in this case. Dr. Sheppel admitted that when Ms. Friedenhagen came to the doctor, she was already terminal. They did not do a complete body scan. They didn't do mammograms at that stage to see if there was cancer anywhere else. She was complaining...
Was Dr. Sheppel able to eliminate the cause of the cancer as coming from anywhere but the lungs?
She testified that she would have done a breast exam, and there's no breast exam results noted. Dr. Sheppel, she was a treating physician, but she testified she had no independent recollection of Ms. Friedenhagen. So her testimony is based exclusively on those 4 pages of medical records also. She testified that she would have done a breast exam, but no suspicious areas were noted in the 4 pages of medical records. What was noted in the records was that there was no involvement of the lymph nodes.
Let me just ask it this way, because I think that the evidence that you presented based on your alternative theory of causation I don't see any evidence of the colon, but this breast evidence to me is just speculation. You're asking the jury to speculate based on a negative lumpectomy, fact that she was taking mammograms, that there may have been relatives in her family history that had cancer. What evidence is there in this case that she had cancer of the breast?
The evidence...
What evidence is there from a doctor or any other source that she was diagnosed with cancer of the breast?
There is none, Judge Shawaya, but there's only 4 pages of medical records. And the evidence is that cancer from the breast is adenocarcinoma, just like the cancer that was found in her lung. Cancer from the colon is adenocarcinoma, just like the cancer that was found in her lung.
It's your burden to establish a competent evidentiary link. And you think that's a competent evidentiary link?
This is not an affirmative defense. Reynolds has no burden in this case to prove it was something other than lung cancer. All we had to prove that there was a predicate here.
I mean, if you want to argue that the cancer came from her breast and that it didn't come from the cigarettes, according to the case law that I've read, you have the burden to establish a competent evidentiary link in order to argue that to the jury. I'm still waiting for you to show me a competent evidentiary link other than the speculation.
We have to establish a factual predicate that there was a possibility.
Possibilities. Okay, now we're down to it's possible that it's possible.
That's the language of Mack itself. Possibility.
Possibilities are a competent evidentiary link.
Dr. Sheppel, plaintiff's treating...
Possibilities, a competent evidentiary link. Are possibilities, you think they are?
Yes, a possibility that is pertinent to the decedent's situation. That's in Mack itself. That is the test in Mack for the admissibility of potential alternative causes. Dr. Sheppel testified that it could have been breast cancer. That's plaintiff's witness. We asked her in her deposition, and she said it could have been breast cancer. That was admitted in the trial of this case. She didn't disavow it. In their briefs, they say, Dr. Sheppel didn't disavow that it's theoretically possible that it could have been breast cancer. There was a factual predicate in this case that
Because a lot of the case law that I read concerning possibilities say that when you talk about possibilities, you're talking about speculation. Possibilities, anything can be possible.
It would be speculation if we were to say brake dust and asbestos causes cancer. Those are the facts of Mack. when there's no evidence in this case Ms. Friedenhagen had any encounters with asbestos or brake dust. It's not speculation to say that adenocarcinoma also comes from the breast and colon. It metastasizes in the exact same way.
What you're telling me is that in any Engel case, that you can bring in the fact that, well, maybe a sibling died of colon cancer, and therefore we can argue to the jury that this was caused by colon cancer, even though there's been no diagnosis of colon cancer of the decedent anywhere by anybody. Or that, a woman had a lumpectomy in the past, but the only evidence is that the lumpectomy was negative. Well, the fact that she had a lumpectomy, perhaps, we can argue that there's a possibility that the woman died of lung cancer rather than cancer caused by the cigarettes, cancer of the lung. Or the woman was taking mammograms, so therefore it's a possibility that because the woman was taking mammograms, that the cancer that was found in the lungs actually came from the breast.
Yeah, so there's a fact.
I mean, to me, that's just incredible.
If there's a factual predicate for that, then it becomes a matter of discretion for the trial court judge.
I'm just,
there's a factual predicate here that she had an expedited mammogram schedule, with the doctors admitted shows an elevated risk. She had a first-degree relative with breast cancer, which the experts admitted was an elevated risk.
So your argument is possibilities are therefore a competent evidentiary link. Possibilities.
Yes. Well, of course, we're only talking about possibilities and probabilities. Okay. We don't have a.
Can you focus on? For a minute? Could you focus on the two-issue rule? You're arguing the two-issue rule applies. Could you please clarify for me, in this case, factually, why the two-issue rule applies?
Sure. So the only question answered by the jury was a class membership question, which brought all the parts of class membership into a single question. Parts of class membership are medical causation, which includes this lung cancer or not issue.
General medical causation.
Yeah, was the cancer caused by smoking? So medical causation is an issue for class membership. Addiction is an issue for class membership. And addiction causation is an issue for class membership. Was the disease caused by an addiction? Not just smoking, but the fact that the person was addicted. So there was one question agreed to by both sides here. So the issue here, the issue that the plaintiffs are asking you to rule on, presumes that the jury determined that Ms. Friedenhagen didn't have lung cancer, when there's no way to tell that. And in fact, it's far more likely, given what I said earlier about the addiction case here, that the jury decided Ms. Friedenhagen wasn't addicted and decided the class membership question on that basis. And so this is precisely in the context of where the two-issue rule should apply. You have to preserve error by asking for a specific verdict form so that you can come to court and say, well, there's some basis that the jury decided this issue.
What is your strongest argument as to the two-issue rule, that the jury basically decided on the addiction issue, or that the cancer came from someplace else?
Both are possibilities, which is why the two-issue rule applies. It's far more likely, I think, that the jury answered the class membership question on the basis of addiction because of the substantial evidence.
Based on addiction?
Yes, based on addiction.
That's what they,
Right, again, because the definition of addiction provided by plaintiff's expert didn't match the facts of this case. And when Ms. Friedenhagen decided that she wanted to stop smoking and cleaned out her entire house, just as my opponent described, she didn't smoke again. That's an unusual case in these cases, unusual fact pattern.
Well, their position is because of the neurological condition she was suffering from, and I believe it was 6 months, that in and of itself facilitated her quitting. You're going to say, then what's your position? After those 6 months, she had a choice to go back to smoking and she chose not to?
Exactly. No question she had a traumatic medical event that caused her to stop smoking, but she could have gone back to smoking. And she made a willful decision that clean out my house, get rid of the ashtrays, the curtains, the carpets, the furniture, everything. I'm not going to smoke again. That could have happened before the 1985 episode. And again, only one described quit attempt that was factually inconsistent with the other testimony when their own witness testified that the definition of addiction is chronic relapsing. There's no chronic relapsing here. Ms. Friedenhagen smoked for a 30-year period continuously, except for that one day perhaps at the beach house when she thought about quitting. That's not a strong addiction case in these cases. These aren't multiple quit attempts. So yes, it's far more likely that the jury said no to this first question on the basis of addiction, not this medical issue that we're talking about. The two-issue rules requires appellants to at least seek a special verdict form, which was not done here.
Do you normally see in these types of cases these, the verdict forms where you ask these individualized questions about each element?
I have seen verdict forms that ask two questions. was the person addicted? And then the second part would be,
But I mean, most of the verdict forms that are presented to the jury in these types of cases are the verdict forms similar to the verdict form we see in this case, right? Would you agree
yes,
with
Your
that?
Honor, I would agree with that. Yes,
You
Your Honor.
agree with that?
Yeah. But there's nothing preventing the plaintiffs from asking for a verdict
Right.
form
There's
question on
no-
class membership
and-
that breaks
and-
out all the
that's
components.
right. And then when you have a verdict form like this, it allows you to argue the two-issue rule.
Exactly.
Yeah.
I mean, this was not something that came out of nowhere for the plaintiffs. They knew, they argued at the pretrial hearing twice about this issue. So they came to trial knowing this was going to be something for them to preserve at trial. No attempt whatsoever to ask for a special verdict form question on the lung cancer issue, whether it was lung cancer or something else. So,
Or addiction.
or addiction, right. So this court has no way of knowing. They're asking the court to presume that all these issues about alternative causation
Well,
actually affect.
you know, I'm just speaking for myself. I know that you were allowed to argue alternative theories on causation. And in my view, I don't think you had a substantial evidentiary link to allow you to do that. I think it was based purely on speculation. That's my opinion.
I understand that just
So
so
we
I...
know, so I know that when I'm looking at the case. I know that you had the opportunity to argue to the jury that there were alternative theories of causation based on this, you know, the arguments that you presented to me. I know that for a fact.
What you're describing is a kind of harmless error review. Was this error harmless or not? The two-issue rule is about preservation.
So it was harmless that you were able to argue that to the jury? I mean, you're saying?
I'm not saying
You're telling
that.
me it was harmless error?
No, I'm not saying that.
All right.
I'm saying it's not preserved. You don't get the harmlessness because they didn't preserve the issue. If they'd preserved the issue by at least asking for a special verdict form, then they could come to court and say, well, there's error and the error was harmful. But we don't even get to that
Your
stage.
argument was there was no way of knowing that the jury had anything improper to rely on. It seems to me like they did, but.
But their doctor testified that it could have been breast cancer.
Yes, Dr. Sheppel, 2135 of the trial transcript. Please go look at that page of the trial transcript, 2135. She testified in her deposition that it could have been breast cancer.
And his opinion was based on what?
Her medical experience and the fact that breast cancer is adenocarcinoma. She had not reviewed this medical journal, which talks about the fact that there was the lumpectomy and the expedited breast cancer schedule, so she didn't know that at the time of her deposition. Another reason why it was important for us to ask the question on cross-examination.
The doctor expressed an opinion that it could have, possibility, it was possible. It was possible based on what evidence that the doctor presented? What were the facts that the doctor utilized to form the possibility of cancer coming from the breast?
That it's adenocarcinoma, and adenocarcinoma from the breast metastasizes in precisely the same way as we see in this patient. Liver, bones,
You can
and
argue
lung.
that in any case.
It's not every case where a person actually has a breast cancer issue and is on an expedited schedule and has a sister who has breast cancer. It's a possibility, but it's not speculation. It's an issue. I understand you don't agree with me, and I don't know whether it's worth to try to convince you, but
I'm looking for evidentiary links, not speculation and possibilities.
But I've
Any
summarized
doctor
evidence.
can testify that there's a possibility.
if there
But
were no...
in any event,
If there were no factual predicate, there would be an abuse of discretion, but this is an issue for discretion. It's a 403 issue, correct? The trial court here excluded it under 403. Trial courts have discretion to make that call. As long as there's some predicate for it, it's a matter of discretion.
did the doctor say possibility within a reasonable degree of medical certainty, anything like that?
And Max says you don't do that because there's no burden on us.
Did the doctor say possibility within a reasonable degree of medical certainty? The certainty would seem to be an oxymoron to the possibility part of it. But did the doctor say any degree of medical probability or anything like that?
No, please read Mac.
It's a possibility.
Please read Mac. That's precisely the issue in Mac. In Mac, the expert was excluded because he could not say to a reasonable degree of medical certainty. The first district said it was reversible error to exclude that expert because the defendant didn't have a burden. So they could bring up possibilities, had a good faith basis to ask the experts of the other side about these potential causes.
Okay.
Thank you, Your Honor.
Thank you.
Thank you.
You have 3 minutes and 33 seconds.
I'll do my level best. I'd like to start very quickly with Dr. Schopel. Dr. Schopel specifically excluded breast cancer. She said, according to Dr. Schopel, If the cancer would have originated from the breast, it would have involved, quote, involved a large breast mass, lymph nodes under the arm. In her normal course of practice, she would have done a breast exam, and it would have been noted in the records. It wasn't.
What page of the record is that?
That's page 2134. She excluded that. They tried to pin her down based on her deposition testimony, and she said, no, that's not correct. So Dr. Schopel excluded that as a possibility. That's where I'd like to start. I'd like to move to the two-issue rule. Look, in an average negligence case, we don't have different special interrogatories on causation, on the absence of negligence. It's the same thing here. Causation, there doesn't have to be.
We also don't have the overriding Engel case as far as res judicata, as far as the entire general allegation against the tobacco industry, correct?
That's right. This is a sui generis.
And they also recognized in the Engel prodigy cases that you need to establish individual causation and addiction, correct?
As elements. As elements.
But that's your burden, right?
Absolutely,
It's your
that's our burden. That is our burden as elements. And if you read the Grenitz case, that's what Grenitz says. If it's broken out into elements and the defense is disproving the elements, and which is what my friend on the other side has said that they attempted to do, disprove the elements, then you don't need a special interrogatory on each one of the elements. So here, the elements of class membership, he said that it's rare, he said, that there are special interrogatories on this. But if it were, it would be causation, as in Grenitz, where they rejected that, and whether the causation was the legal cause, or the addiction was the legal cause of the death. I got that wrong. Whether there was addiction and whether the addiction was the legal cause of the death. With regard to the lay opinion testimony, look, we did proffer prior to trial what these people would say. There was a preliminary ruling that they wouldn't be allowed to testify. Based on that, we felt that it would have been a useless ceremony to try.
Didn't the trial court tell you to proffer it at trial, and then you chose not to do that?
He said that it was a preliminary ruling. That's right.
I don't think that's your best argument.
I think our best argument is the causation point. The alternative theories of causation, I think they were entirely speculative. We think that there was this concept that there was no evidence of addiction. Yeah,
the trial court did more than just tell you to proffer it. The trial court actually put that in the orders on the motions in limine, correct?
I don't recall that. But if that
paragraphs, the enumerated motions in limine,
right.
Specifically for the testimony of Dr. Scheipel, plaintiff must proffer any proposed testimony from Dr. Scheipel regarding addiction. Lay opinion testimony, the same thing. Proffer lay opinion testimony on addiction and causation, correct?
If Your Honor is reading from the order, I'm not going to dispute it. I would like to push back here.
And there was a stipulation, though, at trial that they're not going to go there, and so they just sort of moved on. I mean, that was put on the record.
Right, Your Honor.
And so, why haven't you waived that issue then when there's on the record that we're not going to go there, we're not going to go forward with the proffer, and then you just don't even attempt it?
There was explain that, I'm sorry, Your Honor. I want to be responsive.
At the time that the witness was testifying, there was some indication, I think it may have been by R.J. Reynolds, that you weren't going to go there, something that testimony was not going to, weren't going to attempt to make that proffer, and then there was an agreement, and then sort of moving on.
With regard to Dr. Schopel?
I don't remember which witness. I was thinking that was the lay
I think
witnesses.
that's, if I recall, I think that's correct, Your
Okay.
Honor.
So wouldn't that waive the issue then, at least to those witnesses, whatever witnesses those were?
I thought that was restricted to Dr. Schopel. With respect to the fact witnesses, the lay opinion, I don't recall that. Your Honors, I see my time is up. I don't want to waste any more time.
Thank you.
Thank you, Your Honors.